Hello, good afternoon, everyone. Hello, good afternoon, guys. As usual, I am so excited to be here. I hope you guys are having a wonderful day. Today, we're just here to have a chat. We're going to, of course, have a legal chat. We're going to be talking about conditional permanent residency based on marriage. You're very welcome. Guys, when you come in, drop me a comment. Let me know how you're doing, where you're watching from. You know what's happening. Let me know what's happening. Let me see who's watching. Oh my goodness. Hello, Annie. Hello, Annie Opokuya. You're so very welcome to this live video. I'm happy to have you here. Guys, let me know where the rest of you are watching from and how you're all doing, where you're watching from, how it's going, where you are. I'm recording from Manassas, Virginia. I'm located in the DMV area. And it's a rainy day out here. Oh my goodness, I hate the rainy days. You can't do much. You're just stuck indoors. So that's what is happening in my hood. Let me know how it's going, where you are, and where you're linking up from. Anyway, guys, so let's start with the chat. Okay, we have Prince Nana who's joined us. Thank you so much for joining. I'm really, really happy to have you on here as well. Okay, so we're going to be talking about conditional permanent residence based on marriage. So there's actually conditional permanent residence based on investment, but we're not talking about the investments today. We're talking about marriage. Today, yes, I've actually changed the landscape of my video. I want to see how this would be, whether it would be better in terms of, just the view and everything. So we're doing this video test drive today. All right, guys. So we have, we're going to start with, we'll start with marriage. As always, marriage is the quickest route to get your green card. Of course, a genuine marriage, okay, not the arranged or fraudulent ones. We're talking about genuine marriages. So when you get married to your spouse and you've been married for less than 2 years, once your petition, so you've been married for less than 2 years to your spouse, and then your spouse, who is a U.S. citizen or a green card holder, files a petition on your behalf to the U.S.CIS, which is the federal agency that is responsible for reviewing and adjudicating your application. When you file that and it's reviewed and it's approved before 2 years into your marriage, and so if you've been married for less than 2 years when the approval is granted, then you will be given a conditional resident card. The conditional resident card is it has conditions, and it simply means that 90 days before the expiration of the card, you need to apply to remove the conditions. The card is usually valid. It's valid for just 2 years, unlike the 10-year permanent green card that is reserved for people who have been married for more than 2 years. The rationale is that, if they've been married for less than 2 years, we don't know for a fact if the marriage will they want to test the validity of the marriage, simply put. So that's their way of testing it. I don't know how effective this test is, but that's what they've discovered they want to do. So that's what they do. So the conditional card, which is 2 years, the duration of the card is 2 years. So if you are approved for a conditional green card this year, it will expire in 2023. Okay. Because you've been married for less than 2 years to your spouse who is a green card holder or a U.S. citizen. If you have been married for more than 2 years, so for example 3 years, then you'll be given the 10-year card. And so if you're approved this year, your card will expire in 2021 plus 10 years. Whatever that will be. Guys, this is not the time to be testing my mathematical skills or prowess. This is the law. So I'm not going to be doing any calculations here. Anyway, drop me a comment. Let me know you're watching. Let me know where you're watching from. We're talking today about the conditional green card and the 10-year green card, but we're going to be focusing more on the conditional green card. I will only bring up the 10-year green card to, highlight distinctions and to kind of show you the difference, okay? So you can either file a joint, when the time comes for you to remove the conditions, you can either file a joint petition or you can apply for a waiver. And when we talk about removing the conditions, as I told you, you have to apply 90 days before your 2-year green card expires. That, look, my marriage, I'm still married to my man or my woman or my husband or my wife. Our marriage is real. Our marriage is valid. Can you take off the conditions you've put on my green card? Simply put, can you extend the duration of my green card? And so that's pretty much what you have to do. Yeah, that's it. Today I didn't want to share my screen. I'm using a different device. The device I use to share my screen, where you guys can see the text of the law I'm using, that device, I feel like the camera is a little blurred. This camera is sharper. So my screen is beside me. Today you won't be having a peek at my screen. So bear with me. Okay, so the waiver. So the conditional permanent resident can actually remove the conditions alone. That's known as the waiver. It's always, the regular course of action is that you remove the conditions with your spouse. However, if for any reason your spouse doesn't want to help you or whatever, you can file a waiver. So you may apply for a waiver of the requirement to file the joint petition. Okay, guys, so the waiver, you can file the waiver at any time, unlike when you're trying to file the joint petition. With the joint petition, it's a very time-sensitive process. You have to file it within 90 days of the expiration of the green card, of the conditional green card. However, with a waiver, you can file it at any time. You can file it before, you can file it during or after the 90-day filing window. So it gives you a broader leeway, with regards to the time frame. Okay, so I'm going to be giving you some of the conditions under which you can apply for the waiver. The first one is that there's the termination of the marriage through annulment, through divorce, or death of the petitioning spouse. So if there's an annulment, if there's a divorce, or your spouse who's petitioning for you, that's usually the green card holder, U.S. citizen, if he dies, you can file a waiver. Of course, the dead person can't help you remove the conditions, right? So that's it. And then the second reason is when there's a refusal of the petition spouse to join you. Some people will just flat out tell you that, look, I helped you to get your green card. I no longer want to help you. You can file it by yourself. I have spoken to a number of distraught clients, like people who are very sad because their spouses don't want to help them to remove the conditions of their green card. And guys, here's a catch: if you don't remove the conditions of your green card, you could be put in deportation proceedings, because now your authorized stay has expired and you will no more be in lawful status. Okay, let's read some comments and then we will get back to. We have Rima watching. Hello, Rima. Very happy to have you here. He's watching from Columbus. Columbus, Ohio. You are welcome. Prince Nana says he's watching from Osu in Accra. He's enjoying your lectures. Okay, great. I'm happy that you are enjoying the chat here, the law chat here. So that's the second one. If your husband or your wife, who's a green card holder, doesn't want to help you to, remove the conditions. And then a conditional resident child will being unable to be included in the joint petition of his parents. Example, if the parents died, yes, exactly, before seeking removal of conditions. So sometimes children would also have the conditional resident status. I'll explain that very soon. And then the next one is that the conditional resident is unable or unwilling to file the joint petition because the petitioning spouse is an abusive spouse or parent. So if there's abuse anywhere and the person petitioning for you is unwilling to help you, you can file for a waiver. Okay, apply for a waiver. And then any other reason provided for in the act. So yes, if you need my help with this type of issue, make sure you call my office. My number is right there, and then I'll do an assessment to see if we can apply for a waiver for you if your spouse or your parent or whoever is petitioning for you is unwilling to help you remove the conditions. Okay, so here's a note here. So I'm actually currently using the policy manual. It's the adjudicators field manual. This is the manual that the adjudicators use. It's a very bulky document, and this is what I'm using. And there's a note to the people who will be reviewing your applications. He said the alien, that's a foreigner, may cite multiple reasons for filing the waiver application. In fact, other than the battered spouse or child waiver, all reasons must be applied for at once. Okay. Yeah, so just try to, you tell them all the reasons at once. Don't file one form and then later try to come up with more reasons why you are not filing a joint petition and send them, additional documents. Doesn't work that way. Prepare everything very comprehensively and then send it all in. Okay. Let me see if I'll find what I'm looking for here. Guys, are you enjoying this video? Drop me your questions with regard to, this topic. I usually don't want to go off topic, so just drop me your comments or your questions, and then we'll try to answer them. Okay, good. Okay. So let's talk about, you remember I mentioned that some children may be granted conditional green cards or conditional permanent residency. So a child of, so let's start with the first step. An alien who, based upon marriage, so either a citizen of the U.S. or a lawful permanent resident of the U.S. as a green card holder, obtains permanent residence within 2 years of such marriage. Okay. So with this, you're categorized either as an immediate relative or a second preference classification that we'll go into later. There's a ranking, as you know, of eligible people and beneficiaries. I'll discuss that in another video. But here, the second thing is that any child of such an alien who also obtains permanent residence through his or her parents' marriage within 2 years of the marriage. So if you have a mother who gets married to a U.S. citizen and you, the child, you receive a conditional permanent residence, you will receive it because your mother is married to a U.S. citizen and your mother's married to a U.S. citizen has been less than 2 years. Okay. So that's it. That's the way by which a child can have a conditional green card. And so if the parent, who is the petitioner, refuses to help the child to remove the conditions, then they can file by themselves. Okay. Oh my goodness. We have Samuel Kusi here. You're doing great work. Thank you so much, Samuel. I really appreciate you joining us. And here we have Counsel Donna Ikiamwa. Hello. Hello, Attorney Donna. How are you doing? I'm so excited to see you on here. Great job. Thank you so much, Counsel. I really, really appreciate your presence and your very, very kind words. Okay, guys, so just remember that 90 days before the second anniversary on the date on which you obtain your conditional green card, you need to remove the conditions pretty much. Let's see what is happening here. Okay, I think that today is a very, it's a quite file it. Of course, you need to attach your bona fides. The bona fides are always pretty straightforward, things that show that you share a joint life with the petitioner, or you are related. If you're a child, of course, you need to show proof of the validity of the relationship, which forms the basis of your filing. Okay, so as usual, if it's a marriage, you need to show documentation of joint ownership of property, lease showing joint tenancy of a common residence. That is important. Common residence, it shows that you live your life together. Then documentation showing commingling of financial resources, so bank accounts, joint credit cards used together. Birth certificates of children born into their marriage. Then affidavits of third parties having knowledge of the, when we talk about bona fides, it means how truthful the marriage is, how honest it is, that you did not get married for just to obtain immigration benefits. You actually got married to share your life together. At the time of marriage, you need to show them that at the time you were entering the marriage, you had the intention to share life together. It's very interesting. Some of the case laws, right? They have ruled. Some people actually start out with the fraudulent marriages. So, for example, somebody called, let's say, Charity meets John, and then there's a transactional marriage. They pay, there's exchange of money, and then Charity pays John, look, just get married to me, and then I can get a green card. And guess what, guys? In the course of the transactional marriage or the business marriage, they start spending time together. They start, discussing, okay, I filed this, what's going on. And then they happen to fall in love. So, well, they got married, let's say January 2021, with this arranged transactional marriage. And then they're filing, in the course of the filing process, let's say by June, they start spending a lot of time together. They're having amazing sex. The connection is, the connection, like the chemistry is so thick. Guess what, guys? If this marriage is reviewed, it will be found to be a sham marriage. It doesn't matter what they're feeling after the marriage. The test of a bona fide marriage is at the time of marriage. You see, that's the intent. As I keep telling you, the lawmaker will always look to the intent, and the intent has to be formed at a certain time. And for marriage, it has to be at the time you were entering the marriage. It doesn't matter if you enter the marriage with the idea that, oh, this is a transactional marriage, it's just for papers, and then later you fall in love and you're having mind-blowing, sex, and you guys are just not separable, like you are so in love, and look, you can't even sleep without knowing that he's also not asleep, and you are stuck on him like glue 23 hours in a day. It doesn't even matter. Like, it doesn't matter so far as you enter the marriage with the purpose of evading U.S. immigration laws or solely to obtain immigration benefits, then it's a sham marriage. So remember this, that it's at the time of entering the marriage that it matters. That's when the analysis would be made as to whether it's a sham marriage or it's a bona fide or truthful marriage. Okay, so affidavits of third parties having knowledge of the bona fide. So, you would have to have people from both the man's family and the woman's family saying, oh yes, I know them. That's my uncle, that's my auntie, or that's my nephew. She met her husband at this time, and I've known them, the relationship, it's developed, it's blossomed. They've been married for a year. They love each other, or they've been married. Okay, we're talking about removal of conditions. So they've been married for maybe 1.5 years. They do love each other. It's a genuine marriage. You have to have people from both sides of the family. It's not enough to just have one person from one side of the family. That is always a red flag, right? Because it's like, why people from John's family don't know John is married, and only people from Charity's family know that Charity is married? That's not a good sign. Okay, it shows that somebody may be hiding something. So you want to have the affidavits from both sides of the couple's families and friends chime in and also speak to the relationship, that yes, it's a great relationship. These people spend their lives together, and I have no doubt that they're in love, and And that's that. Okay. So the last thing is also any other documentation establishing that marriage was not entered into in order to evade the immigration laws of the US. This is so important to them. This is really, really important to them. So you have to show it. As I keep telling you, every application package you're sending in is a story you're telling the adjudicator. What kind of story? You have to weave, the strings of the story very nicely and paint a beautiful picture. And that's what I'm here to help you do. I make sure that we're submitting credible, relevant, and probative evidence that is going to, showcase your story, and to make sure that everything is consistent and everything is just, you're not going to give them a reason, because remember, as I keep telling you, the burden is on you, the petitioner, to establish a reason or to show cause why you think that the immigration benefit that you are seeking should be granted to you. Okay, guys, so that's part of my job. Remember, immigration law is not just about filling forms. You need to understand the law. You need to understand the standard of evidence. You need to understand what you are filing for. You need to understand what type of evidence is required, the amount that is required, and what quantity, because sometimes too much evidence is a red flag. Sometimes too little evidence is a red flag. You need to have the right amount. It's just like cooking, right? You need to know the right amount of salt, the right amount of pepper, and the right amount of certain very key ingredients. Without that, everything becomes a mess and a mambo jumbo. Okay, guys, so I'm so happy to have come your way. Keep dropping me some comments. Let me read some final comments before we log off. Today we're talking about the conditional marriage, how to remove the conditions, and of course, as usual and as always, if you have any type of US immigration law wahala, I'm your girl. Don't go anywhere. Just come straight to me. My number is right there on the screen, 802-7800-564. This is what I do for a living. I live by this, and what else can I say? You know where to find me. I'm always here, dependable as always. Okay, so we have a question from Yao. Let me see if I can attempt to answer it. Yao says, what should a man that his fiance is living to US do to go to the United States? Okay, so if you're a man living outside the US, thank you for the question, and your fiance is living in the US, there's a process for you. It depends on the status that your US fiance has. If he has, if your US fiance, she is a US citizen, then we can file a K1 visa petition for you. So we can do the I-129 application and then go on to help you. So it's a two-part process. We can do that for you. File the establish the relationship here, the fiancé petition here, and then when it's approved, it will be sent to the NVC, National Visa Center. And I think you're in Accra or Togo, it will be sent to the embassy, the National Visa Center in the country in which you are based. A foreign spouse is based, and then you will be called for an interview. Okay, but you might want to also consider a marriage-based application. Remember that the marriage-based application is usually I would say that if you're the spouse of a US citizen, they tend to value marriage much more than fiancé petitions. Okay, so you should consider the marriage one. But however, if you still want to do the fiancé, get in touch with me and I'll help you to file it. All right, guys, so that will be the end of today's video. I'm so excited to have come your way. I hope you guys benefited from this. Drop me your comments, drop me the topics you want me to cover. I have a long list of topics I'll be covering within the course of the coming days, and I will keep you all updated with what's happening with the amnesty, hopefully. So stay safe, and as usual, protect yourself, take your vaccines, your shots, and stay warm. All right, guys, take care. Bye-bye.